Welcome to Defending Tomorrow, a series of interviews brought by lawyers of Ecocide networks. We will explore the critical legal battles shaping our planet's future in support of the Stop Ecocide International campaign to recognize ecocide as the fifth crime under the Rome Statute. I am Rodrigo Egido, and alongside my colleague Victor Rujano, we will dip into the current legal discussions surrounding environmental protection through international criminal law with our special guest.
Thank you, Rodrigo. Today we are honored to interview Kate Mackintosh. Kate is the current executive director of the UCLA Law Promise Institute Europe, and she's been at the forefront of human rights, international criminal justice, and now the fight against ecocide. She has played key roles at international criminal tribunals, worked with Doctors Without Borders, and was instrumental in the independent expert panel that proposed the legal definition of ecocide. Recently, she has been promoting the manual on the national criminalization of ecocide through Ecocide Law Advisory project, and I'm sure she's going to speak more about the current work that the ELA is doing nowadays. So, thank you, Kate, for being with us today.
Thank you so much for inviting me.
Well, Kate, my first question to you is why you decided to study for law and why you decided to dedicate your career to human rights and environmental issues.
Oh, wow. Okay. So I studied history at university, actually philosophy and then history. I had no interest in the law at all when I went to university. In fact, I didn't even meet anyone studying law. I was in a completely different, cultural environment, let's say. But I did want to work in human rights. And after I graduated from university, I started trying to apply for jobs in human rights. And, I was totally unqualified and I never even heard back from anybody. And then I thought, maybe if I studied law, I'd be able to work in human rights. So in the UK, we have a kind of fast track for graduates into the legal profession, which is kind of a 2 year study and then 2 years working path, which I took, all the while with the idea of wanting to work in human rights. And then I just, by a complete chance of total luck, after I'd finished my 2 year training, so which articles, as it's called in the UK, in order to, be admitted to the bar, I saw a small ad in a very boring lawyer's newspaper magazine, which said French-speaking lawyers wanted to go to Rwanda, contact Amnesty International. And I rang this number and there were various things followed. And I essentially ended up going to Rwanda with the UN High Commissioner for Human Rights in their human rights field operation just after the genocide there. And that, launched me onto my career and all the really fascinating opportunities that have come my way since then. To shift to your second part, which is about the environment, actually, that was a lot later. So I was working at the Yugoslavia War Crimes Tribunal in The Hague, probably around 2013 or 14. And I was at a retreat. At that point, I was the deputy registrar. So I was responsible for the administration of the court, actually. And I was at a retreat with the registrars from the International Criminal Courts in The Hague, so the Yugoslavia, of course, the International Criminal Courts, others in The Hague, and courts in East Africa that were looking at international crimes. So that was the Rwanda Tribunal, which was in Arusha, and also the people that were setting up two nascent courts at that time in Kenya and in Uganda. And the idea was a kind of knowledge exchange about how to efficiently set up and run an international court. And in the middle of this retreat, we had a presentation from a woman called Paula Kahumu, who's a Kenyan wildlife campaigner, about wildlife crime in Kenya. And it was absolutely devastating. I mean, she really no holds barred. She introduced us to all the elephants, their names, their children, their 33, their whatever. And then the next slide was, the elephant with the whole front of the face cut off kind of thing. And her appeal to all of us there was, is there anything international criminal law can do about this? Because there is impunity at national level because of the amount of money involved, because of the lack of enforcement powers, etc. And our answer really for everybody there was like, well, not really. International criminal law is really about centers the protection of human beings. It's very anthropocentric. But I was completely taken up with this, really impressed by this question. And in discussing with her later, I remember saying something like, yeah, it's really all about the human, but maybe if we could characterize wildlife as part of the human environment. And as I said those words, I just had this vision, oh my God, international crimes against the environment. And of course, even back then, we were all extremely concerned already about global warming, biodiversity loss, and so on. And I just thought, I was like, international crimes against the environment, that's going to happen. That makes complete sense. And that set me on this path, which then led me to discover Polly Higgins, who was working on the topic, of course, then. And yeah, to pursue that through to where we are today and through our work together, Rodrigo, on the panel defining the definition.
That's fascinating, Kate. I'm really interested in knowing your perspective on ecocide. As you know, this movement is growing, and many people still are not aware of this definition, of this concept overall. If you could explain ecocide to someone who's never heard of it in a way that really resonates with them, what would you say?
Ecocide is an attack on on our home. It's an attack on it's destroying the home not only of us human beings, but of all living creatures with whom we share the planet. And that's why I think it's so logical for ecocide to be an international crime, because international criminal law is about protecting values that are so fundamental that they're shared by the entire global community. So that wherever the crime occurs, it's not just a crime against people in that location, but it's a crime against everybody. We might think of the crimes against humanity, the famous international crime, as encapsulating that, I think, in its title. So wherever we can think about crimes against humanity, we can think about genocide, an attempt to destroy a human group, which would be genocide, is not just a crime against that group, right? It's a crime against all of us. We're all poorer if we were to lose a human group. And I think the idea of destroying our home, our planet, our environment is obviously a crime which, wherever it happens, is a crime against all of us. And so in a way, it's almost a quintessential international crime.
If you have to explain what is ecocide in very simple terms, I always try to say something like it's like an environmental disaster that is completely avoidable, or something like this.
Yeah.
How could you explain that?
Yeah, I think that's really well put, Rodrigo. I think that's one of the essential elements. So, of course, when we were trying to work on this definition, that would be something that could be introduced into international law, that could be prosecuted at the International Criminal Court, we had to think about a lot of different elements. And one of these was this issue of, so if we go back to some of the other crimes, maybe genocide. Now, genocide, there are a number of acts that can constitute genocide, but let's take killing members of the group. Well, any killing of a person, I mean, unless it's in self-defense by a law enforcement official, blah, 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 that's going to be a crime. So it's like an amalgamation of individual crimes with a bigger intent to destroy a group. We didn't really have that in defining our environmental crime, right? Because we interact with the environment. We destroy elements of the environment. Humans, we eat animals, we cut down trees, we divert rivers. So there's no easy absolute prohibition. The goal, of course, is sustainable development, and that we live within our planetary boundaries so that we interact with our environment in a way that respects the rights of future generations and means that we can continue to enjoy all the fruits of the planet. So I think that's where your point about being avoidable is really a valuable way of thinking about it. So we're talking about, first of all, we're talking about massive environmental destruction. You said, environmental disaster. So we're not talking about small acts, which perhaps also should not happen, but we're talking about an international crime. So it's a high threshold of damage. And then we're saying there is no need, there is no justification for this. This is not something that is necessary in order for humans to survive, for example. We all understand that we're going to cultivate crops and livestock and, do things like even cut down trees to build roads or excavate areas to build housing. We will do that, but we have to do that in a way that's sustainable. When that balance is completely out of whack and the damage is very high, then we're looking at something like ecocide.
Well, moving on with the next question, you have played a key role in this ecocide movement, and actually you participated in the independent panel of experts on the ecocide definition. This panel proposed a very specific definition of ecocide in 2021. Could you elaborate on the key elements on this definition and the rationale behind them?
Sure. So I could read out the definition to start off with if that's helpful, but it's very dense. So then I'll try and unpack it a little bit. And, Rodrigo can also help us, as of course he was also on the panel. So our definition was as follows. Ecocide means unlawful or wanton acts. That's the first thing. Committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So in a way, it's a short definition, but there's a lot in there. And maybe I can just flag those different elements. So first of all, perhaps the threshold of harm, severe and either widespread or long-term damage to the environment. So we intended that to indicate a very high threshold of harm. In other words, that a lot of damage has been caused or is threatened to be caused to the environment. And we took those terms from existing international legal prohibitions of damage to the environment, specifically in armed conflict. So severe and either widespread or long-term damage. And then we actually also give some suggestions of what those words might mean in the second part of our proposed definition. So in addition to, what does that harm have to occur? No, it actually doesn't. The crime is committed by acts which the person who commits the act knows are substantially likely to cause that damage. In other words, it's a crime of endangerment. The crime is committed when the substantial risk is created. Why did we go that route? Well, a number of reasons. First of all, it has a higher deterrent effect. So causing the risk is the prohibited act. Particularly in the realm of environmental harm, it's not always entirely clear or entirely easy to trace a line from the act to the effect, or at least not for 100% causation. So some are very easy. You can think about a massive oil spill. It's very obvious what the effect is, but others may be less clear. And our advice was that the substantial likelihood of harm was a realistic threshold that a prosecutor would actually be able to establish. And of course, the individual themselves has to know that there is a substantial risk of harm. So we felt that it was also fair to people who would be prosecuted. Essentially, that if you order this to be done, or if you carry out this action, there is a substantial risk that severe and either widespread harm to the environment is going to follow. That is the illegal act. And then actually we put one more criterion in, and that is that the act itself must either be already unlawful, so already prohibited, but of course in many cases in environmental law, it will not be prohibited. This is precisely the problem. That our national laws are not strong enough, and our international laws actually don't address massive environmental harm in a kind of criminal or prohibitive way. So if the act is not already prohibited, if it is already prohibited, then the prosecutor can charge that crime. If it's not prohibited, what do we do? Because there's still a risk, a substantial risk of this really high level of damage. So it's definitely something that we want to prohibit. Well, we put in this criteria that we called wanton, which actually captures the point that we were just discussing. Wanton means there's absolutely no way it could be justified by any social or economic benefit. It's completely out of whack with any sort of principle of sustainable development. So in order to be called ecocide and an international crime, we have a pretty high threshold. There has to be knowledge of the substantial risk. The risk has to be of severe and either widespread or long-term damage to the environment. And the act either has to be already illegal or it has to be completely impossible to justify by any reasonable social or economic benefit.
Do you remember, Kate, some anecdote that you can comment inside the panel, reaching the definition, the consensus, because it was too much work trying to agree in a definition? Is that outcome of consensus? So, what you can tell us about this process?
Yes, I mean, it was such an interesting process because I think it was brilliantly put together, I must say, the panel by the Stop Ecocide Foundation because of the breadth and diversity of expertise. So we really had people specializing in climate law, in international criminal law, in public international law, in environmental law. And that led to some very interesting discussions, right? It would have been a lot simpler, of course, if everyone had come from the same background, but it would have been a much weaker definition, I think. I think most of the discussions could be characterized as being working out where to put the balance between something that was maybe a low enough threshold to capture acts that we thought should be prohibited and a high enough threshold to be actually realistically accepted by states. So, we could all imagine the objections. And perhaps you asked for an example. So we could look at the threshold of harm, severe and either widespread or long term. Now, those phrases appear in two different places already. I mean, it also appears in the Rome Statute, but that's based on one of the two source documents, which are both relevant to conflict from the 1970s. We have the additional protocol to the Geneva Convention, which prohibits, as an absolute prohibition, in fact, as a basic rule of armed conflict, prohibits launching an attack, in the knowledge or using means or methods of warfare that might be expected to cause widespread, long-term and severe damage. The other document we have, which prohibits hostile modification of the environment, prohibits either widespread or long-term or severe damage. So we have one which prohibits, the threshold is all three, so a very high threshold, and one where it's one of the three, so a low threshold. Now, the lower threshold will capture more, of course, in the crime. In other words, it will be more protective of the environment. But the higher threshold already exists in the additional protocol and it's been imported into the Rome Statute. So probably it will be easier to get states to agree to the higher threshold. And that's something that we've discussed a lot. And we came up, and people felt very strongly, both in both directions. And we actually came up with a compromise. So if you remember when I just was talking about the threshold, what we went for is we said, okay, in all cases, it has to be severe because we're talking about an international crime. That can't be optional. It can't be not severe and be ecocide. It has to be severe. But to require the damage to be both widespread and long-term might eliminate situations which we all felt should be characterized as ecocide. And I think especially perhaps, well, both of them. So for long term, it might be actually difficult to determine how lasting the damage is going to be at the point of prosecution. So that could be a problem. In other cases, it will be very clear that the damage is going to be long term, but perhaps it's not that widespread. I mean, it's severe and it's long term. Does it really also have to be across a very large geographical area? So we put those two in the alternative. So those are the kind of conversations that we had in the panel.
And I remember that we looked some samples to reach this consensus.
Yes.
You remember some of the samples. I remember that we talk about some oil spills. Oil spill was a sample. Another sample I remember that was Chernobyl or something like this, because Chernobyl maybe is very long term, but it's not so widespread right now.
Mm-hmm. Yeah, absolutely. And the other issue was a question of remediation, right? So
Yeah.
what if, so thinking about an oil spill, what if it can actually be remediated? Perhaps it costs, takes massive resources to do it. But what if it can actually be remediated so that it doesn't have to cause long-term damage? Does that make the individual less culpable? And of course, someone would have to have done a deliberate act. It's not a negligence crime. But if we can see an oil spill for which there would be criminal responsibility, does the fact that by spending millions and millions of dollars on cleaning it up, it could actually only last a short period of time, despite causing very severe damage over a large area, does that mean it shouldn't be ecocide? So that would be the kind of examples I think that we discussed.
I'm sure that was a very interesting time getting to that definition. And I see that the independent expert panel was successful in a way that right now this definition is the foundation of the proposal that is already on the ICC, following the proposal of Vanuatu, Fiji, and Samoa. Um, it was in 2024. Right now we are in 2026. What is the timeline looking like for this upcoming amendment of the Rome Statute?
Yeah, I mean, we were, of course, so delighted when Vanuatu, Fiji, and Samoa decided to formally propose the amendment. And I think that we've seen some really interesting developments since then. So, first of all, Democratic Republic of Congo came out 1 month later in support as well, so formally supporting it as the amendment. And most of the movement has been in states from the global south. So, just recently, for example, the Organization of African, Caribbean, and Pacific States, which is a huge, as you can tell by the name, a state with huge membership. I mean, an international organization with huge membership from African, Caribbean, and Pacific states has been supportive of the crime of ecocide. I think Ghana has also made a number of supportive statements, and it's interesting to see how these states come to it. So it's all states that are really facing, existential or very serious threats from the climate crisis or other kinds of environmental destruction. So, of course, Vanuatu, Fiji, and Samoa are facing rising sea levels as an existential threat, and they have been, especially Vanuatu, in the forefront of trying to take legal actions around the climate crisis, including at the International Court of Justice. DRC are really interested in this and feel that it's a crucial development because of their biodiversity issues. So DRC has the second largest forest on the planet, with an astonishing number of different species, and they are subject to non-state armed groups pillaging the forest, the illegal mining. So that's their interest. Ghana has come in through this illegal artisanal mining, galamsey, gold mining, which is poisoning their country. So it's very interesting to see what brings different states to see the importance of an international crime of ecocide. But to get back to your question about timetable, I don't know what the timetable is exactly, but I'm seeing it develop a pretty large constituency of support among this, number of countries in the global south. At the same time, we have in Europe, of course, the Environmental Crime Directive, which comes into force next month, according to which all EU member states must criminalise a range of environmental harm, including what they call a qualified offence, which is defined very much in the terms of our ecocide definition. So that means that if they're all on time, by the end of May, all EU member states will have a crime in their national criminal code, which is very similar to ecocide. So if we had, membership of the Organization of African, Caribbean and Pacific States and membership of the EU, if we had those groups of states backing the Ecocide Amendment, essentially it would be adopted. So I say that not that these EU states have spoken in favour of the amendment, but just that why would you object to including a crime in an international instrument to which you are a party if it's already a crime in your domestic law? So I think all these steps are very promising, and I would imagine that that will mean that the passage forward is going to be, easier than it might have been without those developments. I might also just mention that the prosecutor's office has issued this policy paper on how to use their existing crimes to prosecute environmental damage. Now, honestly, it's pretty limited, apart from in armed conflict, and maybe we'll talk about that a bit longer, because I think there are some really interesting new ways of thinking about existing war crimes law. But the rest of it is pretty limited. Nonetheless, I think it has shown that the prosecutor also sees the urgency of trying to use international criminal law to address one of the biggest threats that's facing us, which is, of course, climate change, pollution, biodiversity loss. So there is a momentum coming from a number of different directions, which I think is very promising for the progress of ecocide law.
And it fits with the name of your institute because it's called Promise Institute.
Yeah, that's right.
So why you decided to put the name Promise Institute?
Oh, that's a great question, Rodrigo. So actually the name comes, so the Institute, which is at UCLA School of Law in Los Angeles, was founded with a gift from an American of Armenian heritage. And he had left Armenia just before the genocide in Armenia. But like many of the Armenian diaspora, it's a huge, obviously, event in the history of the Armenian people. So he made a gift to the UCLA School of Law. He lived in Los Angeles to set up a human rights institute, very much with the idea of, this must never happen again. Of course, it has happened. Happened very soon after the Armenian genocide, of course, in World War II, and we continue to see genocides unfolding. But his vision was that he would give the money to train the people, to develop the tools, to try and ensure that history did not repeat itself. And as well as founding the institute, he actually passed away before I arrived to set up the institute, but he had made the gift already. And his trustees, who still, who I still work with, also made a film. So we're talking Los Angeles. So obviously the idea was to make a Hollywood movie about the Armenian genocide in order to share with people this part of history which has been, buried and lost from sight. And that film is called The Promise. And it's a great film, actually. I highly recommend it. I mean, obviously it's about genocide, but, it manages to do that very skillfully in a way that's watchable. And, there's a beautiful love story, etc. But it's very meaningful. And so the idea was that the Institute would also take the name. But the promise is the promise to future generations that we will do everything that we can to prevent atrocities occurring.
Wonderful, wonderful.
Well, and speaking of the work of the Promise Institute and its current project, Ecocide Law Advisory, this is a very crucial resource for states and organizations looking to implement ecocide laws. Can you comment on the building of the team and the work that the ELA is currently doing?
Yes, thank you so much. So Ecocide Law Advisory is a partnership initially with our good friend Richard Rogers, Rodrigo, who has an organization called Climate Council. And Richard and I initially set up Ecocide Law Advisory, and we have a roster of experts who are available to advise. Usually lawmakers. So far, we've been advising MPs and lawmakers who want to introduce proposals for ecocide law into their national jurisdictions. That's been a large part of the work. The most recent collaboration there was support to Monica Lennon in Scotland. Monica is a really groundbreaking member of the Scottish Parliament who is successfully introducing an ecocide bill there. So we've been supporting Monica along with other people. She has a great team of supporters who are trying to help her move forward. At the moment, actually, our main project comes out of work that was done in Ukraine. So both Richard and I, and Climate Council, actually, I would say primarily, were involved in supporting the Office of the Prosecutor General in Ukraine in prosecuting and framing environmental damage that had occurred in conflict under existing law. Now, Ukraine, of course, has, or I say, of course, listeners may or may not know that Ukraine actually already has a crime of ecocide in its national criminal code. There are a number of former states that were formerly part of the Soviet Union that have a crime of ecocide in their national laws, which comes, as far as I can establish, from a model law that was developed under the Soviet system. So many of the successor states actually have that crime in basically the same terms. Hadn't been used in Ukraine, and the prosecutor was really keen to implement it, to put it into action. So I actually was working with him specifically on that ecocide question, and Richard was in the lead, Climate Council was in the lead on developing a guide to prosecuting war crimes under existing war crimes law. And that great strides were made. And I think what driven by the vision really of the Ukrainian prosecutors, we have come to understand that there is actually a lot of law that applies, that can be used to protect the environment in times of conflict already. So we developed a manual led by Climate Council in Ukraine for prosecutors, and now we have a joint project on translating that to be a more general tool. So for civil society actors, environmentalist groups, as well as prosecutors, to be able to look at environmental destruction, both in and out of conflict, and understand how it might be able to be framed as an international crime. Essentially, we're looking at war crimes in conflict and out of conflict crimes against humanity. And there are a limited number of situations in which environmental harm could already be characterized as a crime against humanity. Just to say a little bit about the war crimes, though, because that's really quite interesting. So it's often said that the environment is only protected through one article in the Rome Statute of the International Criminal Court, which specifically mentions the environment. And it sets a very high threshold. It uses the widespread, long-term and severe threshold. And it talks about launching attacks in the knowledge that widespread, long-term and severe damage to the environment will be caused. That is not justified by military necessity. In other words, it doesn't just prohibit that level of damage, it says not only that, but also you have to show that it's not justified by military necessity. So that's a very difficult thing to do. And that crime has never been used at the ICC. But what we've realized by really working with the Ukrainian prosecutors and thinking about what's happened in the full-scale assault on that country is that there's actually some other law that applies. So, for example, the environment is generally accepted to be civilian in character. So normally elements of the environment are civilian objects. Attacking a civilian object is a war crime. So destroying a forest, if there's no military objective, if it's not like hiding the enemy forces, is actually a war crime already. So another thing is property. Enemy property is protected. So where we can characterize elements of the environment, a lake, a forest, agricultural fields, etc., as property, is also protected under certain conditions in armed conflict. So we've been engaged in trying to kind of reveal that this is there, and to encourage people who are trying to protect their environment, specifically in armed conflict, to activate this law. As we wrote a short blog post about it, no longer the silent victim, because the environment is often known as this silent victim of war. And with what's happened in Ukraine and with the efforts that we're now undertaking, which are, of course, would be supported by this policy paper of the ICC prosecutor, who's also highlighting these issues, we're hoping to advance the protection of the environment through international criminal law, even before we manage to bring in the crime of ecocide.
I think we are reaching the end because the times fly. And yeah, maybe the last question is if you have a message to future generations, to people that are thinking that deserve or not to study for law or dedicate their career to human rights and environmental issues, what could be the message to next generations?
I think we're seeing a really creative moment in how to use law to deal with the existential crisis that we're facing, which I think all of us on this call understand is around the climate crisis, the climate emergency, the threat to biodiversity and increased pollution. I mean, that is the existential crisis we're facing. And we're seeing lawyers come together in many different ways to think of creative ways to address that. And honestly, I think we're seeing our global institutions rise to the occasion. I mean, we've seen the advisory opinions on states' responsibilities in the face of climate change from the Inter-American Court for Human Rights, extremely helpful and progressive. And then from the International Court of Justice, not generally thought to be, a particularly progressive institution, really come out and say, yes, there are binding obligations. States owe this to their communities because of the seriousness of this crisis. So at the same time, we're seeing really creative litigation across national jurisdictions around climate and other environmental harm. And of course, in international criminal law has been the subject of our conversation today. Great strides are being made, and I have absolutely no doubt that ecocide is going to be codified on the Rome Statute and become an international crime. So I would really encourage anybody who's interested or excited in this path to deal with the crisis to take it up. We need everybody. We also don't just need lawyers, by the way. We need scientists, we need thinkers, we need activists, we need politicians. But law is a relevant site for activism around this issue. And what I would say to actual future generations, or I hope what we would be able to say to actual future generations, so to the not yet born, is like, we did our best. So I would encourage everybody to do their best. Like, let's do it together. We can do it. We're moving. We're getting there. Let's go.
Absolutely. Kate, thank you so much for being with us today. It's been a pleasure. And to our audience, if you want to learn more about the lawyers for the Ecocide Network, the Ecocide Law Advisory, and how you can get involved, please visit stopecocide.earth and follow us on our social media. We believe that the law can be a powerful tool for change, and we need more voices like Kate's to create the changes we want to see in our present and future. Join us in our next episode of Defending Tomorrow, available on YouTube channel and in the main podcast platforms available. Thank you, Kate.
Thank you so much.